Okay.
And you guys should all get the little notice.
Okay. Yes, I'm okay with this being recorded. Okay, welcome. So I will let Amy introduce our guest, but just wanted to take an opportunity to call us to order. Welcome, everybody. Since we're not going to be voting on anything, do we need to have a roll call, Amy?
Yes, please.
Okay. All right. So I will, Susan, who are you and what are you doing?
Me?
Really, they're two
Oh, I'm
Susan.
sorry, Susan Gary, Professor Gary.
So I'm Susan Gary, formerly taught at the University of Oregon School of Law. I'm an emerita now, and I'm serving as reporter for this committee or work group.
Yes, thank you, Professor Gary. Mr. Hanson.
Hello, I'm Gabe Hansen. I'm a research assistant with the Oregon Law Commission, currently at 2L at the University of Oregon.
Great. Mr. Necky?
Hi, I'm Jane Sternicki, Legislative Counsel for the Uniform Law Commission, just here to protect uniformity as much as we can.
We appreciate your participation. Thank you. Ms. Myers. Ms. Meyer, sorry.
Thank you. Andrea Meyer, Director of Government Relations, AARP Oregon.
Mr. Petty?
Jeff Petty, Probate Policy Advisor for OJD.
Okay. Susan, I'm sorry you don't have your last name on there. I can't remember your last name.
Oh,
I
I'm
apologize.
sorry. I'm sorry about that. It's Susan Cook. I
Okay.
am a associate professor at Willamette School of Law.
Great. Thank you so much for joining us. I appreciate your participation. Mr. Anholtz.
Shane Anholtz. I'm an attorney in Medford.
Mr. Rogers.
Jeremy Rogers, General Counsel and Government Affairs Director for Oregon Realtors.
Great, thank you. Justice Walters.
I'm Martha Walters, Uniform Law Commissioner, and worked on this act back when I was president of the ULC.
Fantastic. Thank you for joining us.
Yes.
Ms. Newell.
Anna Newell.
Thinking you meant, oh.
Okay, Ms. Pescone.
Hi there, Tisha Pescone, one of the staff for the Judiciary Committees.
Great, thank you. Ms. Kohlenbrook, or Krolenbrook, sorry.
Hi, I'm Ashley Krolenbrock, and I'm a solo practice elder law attorney based in Milwaukee, but I practice statewide.
Great, thank you. Mr. Raji?
Justice Raji, Director of Advocacy and Civic Engagement, Urban League of Portland.
Great, thank you for joining us. Ms. Milio.
Hi, everyone. Tess Milio. I'm with the Oregon Association of County Clerks, and I'm going to be off camera today because I'm on the road.
I appreciate your joining us. Ms. Palmer Dubrow?
Hi, I'm Tabitha. I am State Counsel with the Fidelity National Title Group. I'm based in Portland, but we're throughout Oregon.
Great, thank you so much. And then Mr. Shields.
Hi there, Matt Shields, Oregon State Bar, just checking in.
Okay, great, thank you. Amy, I will allow you to introduce or ask that you introduce our guest speaker today.
All right, great. Well, thank you everyone for coming today. If I stutter for a second and say, oh, I have to let someone in, I apologize. I want to say thank you to Jane from the ULC for helping us connect to JC Fisher, who is a practitioner in Alabama. She's a senior associate attorney at Gregory Varner in Birmingham, Alabama, and she has done a lot of work on the Uniform Partition of Heirs Property Act in Alabama. The act passed a little bit more than a decade ago, so we're lucky to have JC here because she's going to have experience of how it actually, what the implementation looks like and how it all works. So Jane or JC, I don't know if you have anything to add, or JC, you want to get going, whatever works best for you. And if it would help, I have your presentation and I can screen share if that would be helpful for folks.
Or you could just allow her to share.
That too.
Whichever
Casey,
you
I
prefer.
think you should take it away.
Cool.
You're the expert here, so
Cool.
thanks for being here.
I can do that. Thank you so much for the introduction, and thank y'all for being on this call. So I want to give a little bit of background.
on Alabama. So yes, we have had the UPHPA for over 10 years. However, it has not been widely implemented until probably the last 4 to 5. And so I'm going to tell you what not to do once you pass this thing, because I have faith that you will. Do not roll out the education to the judiciary and the lawyers, because otherwise they won't know about it. And our bar made that mistake. They made a grave mistake of not educating the attorneys and judges that we even had a new statute. And it was not until I started really taking on heirs property partition cases that the judges were finding out for the first time that we even had one. And that was like 5 years ago. So I don't know how much land was lost to the old statute that should have been done under the new statute, but I will say that. Definitely don't make that mistake. But without further ado, I want to basically kind of present a CLE I just gave to the state bar last week or a couple weeks ago. And I'm going to like kind of rush through it because it was like for an hour, but we don't have to talk about all the things. So I just sent a request to be able to screen share because I did add some changes just based on some of the questions y'all sent so that you could, not changes, but additions.
And let me just add really quickly, JC, those questions were primarily pulled from conversations that we've had in the work group so far. So those were things that were discussed by the group over the last 3 months or so.
Sweet. Good stuff. Okay. Well, yeah. So let's talk about partition. Obviously, we know what partition is. That's why we're in this room. But, this allows co-owners of real property to legally separate their interests, whether it's in cash or physically by dividing the land. And it's used when one or more owners decides they don't want to hold the property jointly anymore. They want to either sell it or get their own piece. The court's going to evaluate whether the property can be physically divided, which we call a partition in kind, or whether the property is to be sold. This partition process is supposed to ensure that every owner receives the fair value of their interest. And more so, the UPHPA, the Uniform Partition of Heirs Property Act, seeks to do that, to ensure that everyone receives the fair value of their interest either in land or in cash. But partition most often arises in heirs property where title is held by multiple family members. We know what heirs property is. It's property that passes either intestate or through a poorly drafted will to multiple family members. You might be thinking, some of you, well, wait a minute, how is heirs property passed through a will? Well, when someone leaves their property to all their children, they have created heirs property. It is property owned by multiple heirs. So just note that wills can create heirs property, and they often do. The most famous partition case I ever had that you can find on the news is the case of the Woodson family, where the original landowner had a will that was probated, and he left it to all 10 of his children. That case was litigated under the old statute before the UPHPA, and that's a great case study as to why the UPHPA needs to be passed. It would have made all the difference in my client's case had it been litigated under the UPHPA. And again, that's the Woodson case in Auburn, Alabama. I was able to work a miracle on that one because I got hired the 18th year of litigation and took it to the Supreme Court and made that guy feel really bad about himself. And so we were able to get a really good agreement. But if I had the UPHPA, I would have had way more options. All right. So Alabama partition statutes, we have 2 statutory regimes. Okay. So we still have the old partition statute. That's something really important to note because one of the questions that I saw was, well, how does this affect other partition cases that are not related to heirs property? It doesn't. It really doesn't. There is still a statutory regime for partition actions that don't fall under heirs property that some people would say is simpler. It depends on what you define as simpler, but our heirs property is all litigated under the UPHPA. And so I'll note this, and I just talked to one of the drafters recently about why they did this, but you will see that the definition of heirs property under our state statute is very widely broad. So the case has to be filed after January 1st, 2015, which is when the statute became effective. It's held as tenants in common. There's no written agreement governing partition among the owners. One or more co-tenants acquired their title from a relative, and at least 20% of the interests are held by relatives or those deriving from relatives. And you're probably like, what the heck? That's really broad. That was the point. So the realtor and creditor and speculator part of this drafting committee, they were hesitant about the statute for reasons that you can imagine, maybe. And the only way that we could get them to agree to pass this thing ultimately, not we, but the drafters, this is what I was told. One of the big reasons was that they had to define that it was only applicable to heirs property. And which makes sense. It's the Uniform Partition of Heirs Property Act, sure. But the drafters told me that they tried to make that definition as broad as possible to ensure that any family land would fall within that category. And to date, I mean, I'll be honest, in the last 5 years, I have only seen one partition action filed outside of the UPHPA because it was not heirs property as defined by this statute. So in that situation, it was three owners that were not siblings, not relatives. They were just like friends that were owning property for whatever reason together. But yeah, most of this definition is going to cover a lot of property that could be considered heirs property. And if these conditions are met, the UPHPA governs, the judge declares it as heirs property, and that the UPHPA applies. Okay, so that's typically kind of how that works. The non-UPHPA statute remains available in Alabama. It just doesn't apply to heirs property. So then this slide is in here. I kept all the slides that I used for the state bar because I will say that in our state, attorneys' fees are allowed to be awarded in partition actions. The real estate attorneys were really concerned that if we passed the UPHPA, that they would not be able to collect their 10 to 15% of the sales price after the case concluded and the property sold. Our statute says that attorneys can still collect their fees in the same way they can collect their fees under our old partition statute. So they can still be awarded 10% of the sales price. That 10% is established by case law, but there is a statute, 34-360, that allows for attorneys to collect fees from the sale proceeds. I've also seen, just so you know, courts award attorneys' fee splits. What do I mean by that? Plaintiff's counsel typically is the one who gets to see this 10% fee out of the sale proceeds for their work in the case. But judges have often said, if the defendant's attorney is helping move this case along under the UPHPA, we're going to split that 5% and 5%. So that is something you should be aware of that Alabama did as it relates to attorney's fees. If your concern is, well, how am I going to get paid for this work? Most of the time, the plaintiff's attorneys are actually getting paid from the sale proceeds if the property goes to sell. If the property goes to sale. I always collect a retainer because I'm not fooling with that, but most attorneys will wait till the property sells. All right, there was a question about commissioners. I'll be honest, we don't typically use them, but we absolutely have a statute and case law for them. I think they are underutilized. They probably should be utilized a lot more. As it relates to the UPHPA, we used to see them all the time. In our old partition statute, like our standard partition statute, you would see a commissioner in every single partition case. I'll be honest, in every UPHPA case I've had, we have never had a commissioner. And I don't really know why. I guess the reason is that it's just not really necessary when the attorneys are really working together to make sure that the statute is complied with. We just didn't need one. Our judges were, willing to do what they needed to do. So The commissioner under our statute is supposed to be a disinterested and impartial and not a party or a participant in the action. There was a question about, well, what does that, like, how practically, how are you finding these people? Typically, it is a local attorney that's completely unrelated to the case, doesn't have any strong relationships with either counsel, or maybe they have a decent working relationship with both attorneys on either side. But it's just supposed to be an impartial person. And that is the whole point. It can also sometimes be a realtor, like it could be a real estate appraiser or a real estate professional that is coming up with an opinion. It doesn't necessarily have to be an attorney, but they have to be appointed by the court to help fairly divide the property among the co-owners. In my opinion, it reminds me of a guardian ad litem a little bit. Someone who is, coming in. I mean, a guardian ad litem isn't always impartial, but someone who's coming in and sending a report to the judge to say, look, judge, this is what I think should be done. And the judge is often going to say, well, the commissioner said that, this was their opinion. That's what we should do. But they are supposed to be independent. They examine the property and order surveys if necessary. They divide the land into shares that are as equal in value as practicable. They're supposed to consider factors such as the land quality, location and access, other physical and economic advantages. They're supposed to really look at that statute and say, well, judge, this is my analysis of the best way to divide this property for everyone, whether it's partitioned in kind or sold and divided. Judge, this is my opinion of what you should do. And they will often prepare like plats and maps, present evidence. I mean, they'll do all kind of stuff. And ultimately, like a GAL, they would submit a written report for court approval. And in the old cases, I never saw a judge disagree with a commissioner. I mean, it just, whatever the commissioner said was kind of what went, because the commissioner served as like an investigator, and came up with an opinion along the way. But when selecting a commissioner, all our statute says is what I put in the quotes at the top. That's all it says. So, the court has wide discretion as to who they're going to appoint. Commissioners are not jurors, though. They're similar to neutral arbitrators. Their report is kind of treated like an award in a way, and generally the court will uphold the report unless there's a clear error of law or fact. And we've got some case law on this, or evidence of unfairness or bias. You can file objections. They need to be timely filed, and the burden is really on the objecting party to prove that there was a clear error of law or fact or evidence of unfairness or bias. I've never had an issue with this. Like, even in the old partition cases, I've never seen a commissioner's report actually be challenged. But I'll be honest, it's probably because the people who needed to challenge did not have access to counsel or access to justice. So, you can't really challenge something you don't know how to challenge. So let's get into the meat of it. The UPHPA, you guys probably know the general steps, what the protections are, and I'll talk about how it applies. But it enhances the notice requirements. It requires an independent appraisal of the property at fair market value, a right of first refusal for the family members who want to keep the land, a preference for partition in kind. Of course, this only really applies if you have enough land to work with, and we'll talk about that in a minute. And then if all of that fails, an open market sale, but they can also do a private sale if an open market sale is not the best option. And then worst case scenario, it goes to auction. What we saw prior to the UPHPA was that the property was always sold at auction on the courthouse steps. And I have actually served as an auctioneer in those cases before. Not a lot of them, but a couple of them. And I mean, it literally was on the courthouse steps. So the notice requirements, there was a question about that, about this sign. So our statute says, you must provide notice of the partition action to all co-tenants in the standard way that you would under the rules of civil procedure, okay, under your state rules of civil procedure. But you also have to post this conspicuous sign. And Alabama said it needed to be 11 by 17 inches on the property. It's like a standard yard sign. And then it says what it must state, that the action is commenced, identify the name and address of the court, common designation by which the property is known. And then you can ask the court to require the plaintiff to publish the name of plaintiff and known defendants. And I always do. I always ask, the court to require that the plaintiff and defendants be named on the sign so that if a neighbor or a pastor is driving by, they can identify, hey, JC, I drove past your property and there was a sign that said your property was subject to a partition action. I don't know what it means, but you need to know that it's on there. So that's kind of how that works. Now, as far as service goes, the sign is in addition to your standard service of a summons via certified mail, sheriff, process server, whatever. And then, of course, you'll have those situations that I'll talk about in a second where they'll move for service by publication. And we'll talk about that in a second. The independent appraisal, unless all co-tenants agree on a value, the court must determine the property's fair market value. I can tell you how it used to work. It used to be that the court would look at plaintiff's attorney who was like, had been doing real estate partitions for 35 years or whatever. And he'd say, hey, Woody, you got a buddy who can walk over to that property and appraise it? And it was just some like realtor that, kind of worked in the area. And the realtor buddy would walk over on the property and say, looks like we could sell it for this much. And then the Woody would come back to court at the next hearing and say, well, Judge, my buddy said that it could sell for $85,000. And then the judge would say, great, let's adopt that. And that would be the value. And then what would happen is when the property got sold on auction, the families got pennies on the dollar. I'll give you an example of the change that the UPHPA has made. I had a case in Hale County probably about a year ago. The plaintiff's attorney did exactly that. I got a buddy who could walk over to the property and say what it costs. He's a real good realtor in the area. Realtor walked over there. He said, yeah, I think the property's worth about $185,000. I said, Judge, no, the UPHPA requires an independent appraisal. We do not have an agreement between all co-tenants to agree otherwise. I'm going to move for an independent appraisal. The judge said, well, it looks like I have to do that because the UPHPA mandates it. That appraisal came back at $480,000. So that's an example of the difference that this requirement makes for families. And in that case has since concluded. I had 3 clients who got a partition in kind. The rest of my clients decided to sell. They think about the difference in money that they got from those sale proceeds if they had just accepted Buddy's appraisal. So something to think about. The court, I have had one case where the court said an appraisal would not justify the cost. The land in this situation was a very small lot. It was probably only worth like $5,000. By the time all the expenses would have been deducted and an appraisal would have been performed, the appraisal was going to be like half the cost of the value of the land. The judge said, we're not doing that. We're not going to do an appraisal. It just doesn't justify the cost. And the statute does allow for that. Okay. Co-tenants also have the opportunity to object to the appraisal. Also, I'm insulting y'all's intelligence, I'm sure, by saying that co-tenants is what we call co-owners, at least in Alabama. I think it's in all of the UPHPA language, but that's what we call co-owners. All right, so then we have the buyout rounds. We get 2 in Alabama. I now know that not all states have 2, but we have 2. The first buyout round is where the people who want to keep the land can buy out the people who want to sell the land, okay? That's the best way I can describe it. It's a right of first refusal. So if cousin Joe files a partition to have the property sold, and I want to keep the property and I'm an owner, I can say, no, Judge, I want to exercise my right of first refusal and I want to buy cousin Joe out. Okay, that's the first buyout round. I want to also note that attorneys have tried to default against silent heirs early on in the case. So like if you're a litigator in this room, you know that if you serve a defendant with the petition and they don't file an answer within a certain amount of days, you can motion for default to have the judge file a default against them, to do an entry of default against them so that they're bound by whatever the order says. Our commentary in our statute says that a failure to respond means that they're deemed to have objected to the sale. So I've had lots of plaintiffs' attorneys say, well, I'm going to default against these heirs because they haven't filed a response, and force the sale of their interest. And the statute actually says if they've been served and they don't respond, they also get this right of first refusal. Okay, that's the summary of it is they also get the right to buy out. They still need to be served with notice. They still need to have the right of first refusal because they're deemed to have objected to the sale under the statute. They have 30 days to file an election. So if the judge says the Hunger Games have begun, the buyout rounds have begun, the heirs have 30 days to file an election to buy out, and they have 60 days from there to pay. Let's talk about practical, right? So practically, the way that it works is that I have asked for many extensions for my clients to have the ability to pay for the buyout because capital continues to be an issue in some of these cases. And so access to capital, sometimes families are not going to have access within 60 days, right? So, the attorneys will do a good job of collaborating and cooperating and working together to ensure that if they need extensions, they can get them and working with the court to do so. I've never had an attorney tell me, no, I couldn't get an extension because I always was reasonable about the request and, kept them up to date. But that's the timeline that we have in Alabama. I will say that these timelines are excellent. They are so great. If you look at the Woodson case that lasted 18, 19 years under the old statute before we had a UPHPA, there were no deadlines as to when all this stuff was supposed to be accomplished, which was part of the problem. The UPHPA sets very stringent deadlines, like very strict deadlines as to when things are supposed to be done. And it's all throughout that statute, okay? If more than one co-tenant wants to purchase the property, the court can divide the seller's interest between all of the buyers according to their ownership shares. Basically what that means is, let's say you have some sibling sets that say, well, we want to continue owning some of this property together. We don't want individual pieces. The three of us were raised on this property. We want to own this property together. We want to buy out together. And the judge will say, okay, great. I don't care. Whatever. Somebody just buy it. So the judge doesn't care as long as it gets resolved. Then we have a second buyout round. This is where the people who are asking for a sale can buy out the other people asking for a sale. Not all states have that. We have that. When I talked to the drafters about why we had it, I think a big reason was that the goal was to maximize the fractional interest and reduce the number of heirs as much as possible. And part of that reason, I think, was because they were thinking about the court. They were thinking about the clerks who would have to issue all of these checks to people. And, if we could minimize the number of heirs and, some of the people that, like the main plaintiff who's wanting a sale, could buy out the other people who consent to a sale, then the clerk only has to write one check to that plaintiff who's already consumed those interests. That's speculation on my behalf, but that's the only reason why I can think that second buyout round is there, I guess. And I haven't gotten a clear answer as to why it's there, but it's there. If no co-tenant files an election to buy out in the first round or the second round, the court sets a final hearing at which time the court considers whether the property can be partitioned in kind or physically divided. So, I have lots of success stories on this particular subsection of the statute. There's a preference for a partition in kind. In Alabama, we have a ton of big rural properties. We have lots of lots too, but we have a ton of rural property that could be partitioned in kind. So there's a presumption in favor of partition in kind unless it results in great prejudice. And these are some of the factors that the court can consider. Is it practical to divide this property? Is there an economic impact? Is the property going to reduce in value if we divide it up as opposed to keeping it whole? That's something that the court can consider. What's the duration of ownership and ancestral value? Think about how that would have helped my client Corinne Woodson, who was 84 years old in that old partition case in Auburn. She had lived on that property for 60 years. Her husband built the house for her when she was a teenager, when they got married. And he had built that home with his own hands, raised all of their children in that home. And that was not any evidence that the court could consider under her partition case. If she had been able to litigate that case under the UPHPA, then the court could have considered the fact that she had been living on the property for 60 years and it had significant ancestral and sentimental value. And so that's one good thing the UPHPA has done. I will say that in many of my UPHPA cases, this factor alone, that sentimental value factor, has helped me win lots of partitions in kind. I had a case where I had an 86-year-old client who got on the stand and talked about the white mud holes in Alabama. Alabama has wonderful minerals, kaolin, which is like a white mud that is used for medicinal purposes. And in the 20s, her family, her 20s to 50s, her family would walk the trail to those white mud holes and gather that mud, and they used it for medicinal purposes. And I tell you, the judge was just sitting at the bench like this the whole time. I mean, just so like enlightened and so like amazed at this story by this elderly woman of, you know, the value of that property from a sentimental perspective, and how it, you know, was used in that way. And I mean, I knew I was getting the partition in kind, putting that elder on the stand. And there were several other elders who testified to that effect. So it's made a good difference in that case. And she got her piece. And guess what? The rest of the property was sold, which is what everybody else wanted. You know, she was able to keep a portion that was worth the value of her piece, and the rest of the property got sold. And she was happy, and the rest of the heirs were happy that wanted their sale. Lawful use of the land can be considered. Contribution to taxes, maintenance, and improvements can also be considered. So lots of cases where my client is the only one who's been paying taxes for, 30 plus years. They've been paying all these maintenance expenses, and the judge can consider that when my client's asking for a partition in kind. But let's talk about the likelihood. It's not an option for urban heirs property. So you can basically like cross this out when you're talking about urban land, lots 2.5 or 0.25 acres, half an acre. A lot of time it's just not an option to actually divide the property. And the judges are going to be really reluctant to physically divide it, because they're going to say, well, who gets the house? Who gets the road frontage? Who gets the creek? Who gets the rocky side? It's so much easier to divide proceeds from a sale. But that's where the attorneys come in. That's where good lawyering comes in. It's always good to engage a surveyor to present a proposed survey. Maybe you need a commissioner to come in and give an opinion of, well, Judge, we got a survey done and it looks like this property can be partitioned in kind, to help bolster the argument that it can. Of course, you're taking a risk because that person is supposed to be independent. But if you feel really confident that hopefully the commissioner will agree. You can consider a partial partition in kind. I've done lots of those where I said, well, Judge, I know we have 20 heirs and, we only have 20 acres and it's shaped like the Titanic, so we can't divide this up in 1 acre parcels, but you've got 16 of them who want a sale. Give them their sale and let my clients have first pick on where their land is going to be that they're going to keep, such that that land does not diminish the value of what's going to be sold. And you work that out. That's just good lawyering. And then you negotiate. Every case I work my tail off to negotiate with plaintiff's counsel. You just got to have some collaboration and civility among attorneys in these situations, like any other case. So these are the final disposition options. So it's a dismissal without prejudice if no sale is sought and a partition in kind is not possible. What that means is, let's say you have a family member who files for a partition in kind, like they file a petition for partition in kind. They never ask for a sale. The judge says, well, we can't partition it in kind. The topography of the land doesn't allow us to do it. You got 80 heirs and 5 acres. How am I supposed to do that? In that situation, the judge is going to dismiss the case without prejudice, which means it can be filed again, obviously. The second option would be dismissal without prejudice upon successful buyouts. So in this situation, and I've had lots of cases where it ended at the buyout. My client buys out the interest of everyone who wants a sale. The judge is going to go ahead and dismiss the case without prejudice. Okay, and my client walks away with the interests and a deed of all of those interests that she purchased. And then open market or private sale if the buyout rounds and the partition in kind fails. So this is where you have a plaintiff who files for a partition by sale or a sale for division. Nobody can afford to buy them out in the first buyout round. Nobody buys them out in the second buyout round. The judge says the property can't be partitioned in kind. They're going to go ahead and proceed. The judge is going to proceed with the sale. Okay, in almost every case, if it comes to that. So the open market or private sale, I've seen this work so many different ways. There's so many different ways you can do this, really, and the statute allows for it. It has to be listed with a licensed real estate broker for sale at a price no lower than the fair market value assessed by the court within a reasonable period of time. Reasonable period of time, I have actually had to use that. So, for example, we got past the buyout rounds, we got past partition in kind hearing, and it was not a good time to put a house on the market. Like it was like right before Christmas, right before Thanksgiving or something. And I was like, this is not a good time. And I went ahead and had the realtors come in and say, this is just not a good time to put a house on the market. And so we waited until the spring, and some of the heirs were upset because they were like, well, we need this sold right now. It was reasonable, the court determined, for us not to sell that house or list that house at a time when the market was dead. And it just was, nothing was going to sell at that time. The court can order a sale by another method if open market sale is unsuccessful, but not only in that situation. I have a case right now where we had a neighbor who was offering more than fair market value, like off the rip. Like this person was like, I'm offering way more than fair market value. We asked the court for a private sale and they said yes. They were like, just go ahead and do a private sale since it's selling for way more than fair market value. Equitable adjustments and contributions. A lot of people want to know, well, wait a minute, how are we supposed to get our money back for all these pro rata property taxes we've been paying for all these heirs that, all of a sudden they're getting sale proceeds, but they don't have to pay me back for the pro rata share of ad valorem taxes I paid over the last 10, 20 years? Well, the courts can adjust the equities under not the UPHPA, but a statute that the UPHPA allows, which is 35-623A. That's under our old partition statute. The judges always allow us to request equitable adjustments for taxes, insurance, fire dues, timber harvest, rents, profits, improvements, or necessary expenses. I've never had an issue getting that if I asked for it. I will say this, there are some states that explicitly incorporated it in their UPHPA. I want to say those states are either, I don't know which ones, but they're either Missouri, Florida, or Texas. I consult so many people on litigators on UPHPA in different states. I just can't remember which state it was. But one of those three states has an actual clause in their UPHPA that says that the court can adjust the equities. They can adjust the accounting or something like that. We just kind of do it under our old partition statute that still applies in certain cases, and just under like public policy reasons. The courts are just like, yeah, I mean, it makes sense to deduct those amounts. I'm not going to... Okay, practically, if you're an attorney on the call, this is like really, really crucial about litigation strategies if you're going to adopt the UPHPA. This is what's required to make sure this thing goes smoothly, okay? Lawyers got to do their research on the front end. Like, too often I'm seeing people file partition actions and they've not even done a freaking title search on the property, which is just like unreal to me. They don't even know what they're getting themselves into. And they're going to be underwater before they know it. So I always recommend, attorneys do title examinations, investigate unrecorded deeds, all these things that are listed on this. Look at the freaking family tree, do a family tree, get the client to do one, stuff like that. And I've done affidavits of heirship before I filed litigation. Absolutely. I don't know if y'all have those in Oregon, but we have them in Alabama, where we can actually record an affidavit of the heirship of the decedent in the probate office. in the probate records. And then do a physical inspection of the property. This is just like stuff that real estate litigators should do. Like, they should just know to do and they should do. But unfortunately, they don't sometimes. They want to take the easy way out. All right. Quiet title is kind of built into our UPHPA. It's not necessarily explicitly stated that way, but it's kind of like obvious, and I'll explain why. You have to know who owns what before the buyout rounds can begin. Also, our applicability statute says the court shall determine whether the property is heirs property. How is the court supposed to determine that it's heirs property if they don't know who the owners are? They have to determine that. I mean, so we kind of have our quiet title built into the UPHPA because the court is going to determine who the heirs are. We have an initial hearing typically where the plaintiff puts on evidence of who the heirs are. This is like, family trees and death certificates, and you put the elders up sometimes to testify, who's child of who. They're basically reciting the book of Genesis for the family. And, you use things like hearsay exceptions, family records, ancient documents, reputation evidence. Sometimes we'll do discovery because it is, civil litigation, at least in Alabama. We run it through our circuit court system, so our trial court system, which I recommend because in a state like Alabama, your probate judges are not lawyers, which is a problem. Sorry if your probate judges are not lawyers and there's a probate judge on this call, but it's a real problem. I mean, so we run it under the circuit court where we know our judges are lawyers. And so we will have that initial hearing. The court will determine who the owners are, what fractional interest they own, and that it's heirs property kind of all in one rip at that first hearing. Now, this is where I talk about service. So a little while ago, I was talking about how standard rules of civil procedure as it relates to serving defendants, plus the conspicuous sign. Well, here's what, in practice, plaintiffs' lawyers will do wrong. They will, the day that they file the petition for partition, they will file a motion for service by publication, asking the court to go ahead and publish to serve all known and unknown heirs. What they're not doing is complying with the rules of civil procedure that say they have to have an affidavit of due diligence before publication that shows that they have exercised reasonable diligence in ascertaining the location and identity of the heirs. And they're not doing that. And the judges let them get away with it a lot of the time. They'll say, well, judge, we don't know where all these heirs are. There's no way to know where all of them are. And so let's just serve everybody by publication. And sometimes the judges will say yes. And I'm going to fight that like all hell. And I do, which is why I have that Latin phrase up there, which means, basically pursue justice, even if it brings down the heavens. And so I'll challenge that like all hell and say, judge, no, they need to demonstrate efforts that they've made to actually find these heirs. Like they haven't even got on Ancestry, judge, like they haven't done anything. So, and the judges will always agree. Oh yeah, you know what? Maybe we should make them do that research, or I'll ask for a GAL to be appointed to represent the unknown heirs, which I do in every case in a partition action, because if I want the title to be clear, I want it to be clear. Like go ahead and ask for a GAL to be appointed, a guardian ad litem to be appointed to represent any potential unknown heirs. That way the GAL comes back and testifies, judge, I did my due diligence in searching. I couldn't find anyone, but I'm still willing to represent the interests of any unknown heirs throughout the duration of this case. And I just do that to CYA pretty much. These are just practice tips. That's just practice tips for after it's passed. And I guess, I talk about tracking statutory deadlines meticulously because the UPHPA sets a lot of deadlines. There's a purpose for that, like making sure that the case runs, like that it's moving. Those old partition actions, so many times, especially if there were lawyers on both sides, they just like drug out. And in this situation, those deadlines have to be complied with. I talk about do not file a sale for division action unless the client is prepared to sell. One big difference, obviously, from the old statute to the new statute is that under the old statute in Alabama, plaintiffs and defendants had equal rights to buy out. And there was this famous Alabama Supreme Court case called Jolly v. Knopf from 1984, where the court determined that it was a violation of the plaintiff's constitutional rights to not allow them to buy out. And all the plaintiffs were developers and speculators. So that ensured that the developers would always be able to outbid the family members for many, many years until we got the UPHPA. The UPHPA says, no. The family has the right of first refusal if they want to keep the property. So I always tell plaintiffs' attorneys, don't file that sale for division unless you're prepared to get your client's interest snatched. Because I want to give real quick an example I had in a rural county where a plaintiff filed a partition, the attorney promised his client that, well, nobody's going to be able to buy you out. This is like 337 acres. And it's you get the right to buy out as well. So, I mean, you'll be fine. You're going to get clear title to this property by filing this partition action. Unfortunately, that attorney was not aware of the UPHPA. I was representing one of the heirs. I called the attorney. I said, "Oh, great. We're happy to purchase your interest. You asked for a sale. We'll buy it in the buyout round." And he was like, "What?" And he said, "You can't do that." I said, "Yes, I can. And it's mandated. You don't get to decide now. You don't want to sell a sale? Great. Go ahead and dismiss it. We'll file a joint motion to dismiss." So to prevent a malpractice claim, he went ahead and gave me a partition in kind for my client's interest, and then his client was able to get a partition in kind for the rest of the interest, and he bought out all the other people. But yeah, just know that was a lesson he learned. The UPHPA gives the family who wants to keep the land the right of first refusal. And always read your uniform and state-specific commentary if you're going to practice this stuff. Let's see, does any of this apply? Okay, we talked about earlier how silent defendants, they're deemed to have objected to the sale under our UPHPA. Their interest still may be sold, and that may be a question that one of you had, was like, wait a minute, so if these people are deemed to have objected to the sale, how are you supposed to get rid of their interests? You can get rid of them later in the case, and there's a loophole under 356A7 that allows you to ask the court to buy out those silent people during the buyout rounds. So there is a way to get rid of their interest. Also, if you get all the way through the buyout rounds and all the way through the partition in kind hearing, you can ask the court to go ahead and sell everyone's interest at that point. Like that doesn't prevent you from being able to do that. And the court has the discretion to do so in certain situations. Let's see. Access to capital is a practical barrier that you should be aware of, and it will be. It typically is. I mean, families are often, at least in the southeast of the United States, they're land rich and cash poor in a lot of situations, and they lack financing opportunities. So I've had to really get creative with financing opportunities in this situation. And then for us, we have limited attorney familiarity with the UPHPA, which leads to mistakes and missed opportunities. And so we are seeing that. But again, the error was with our state. The error was that the state bar did not push the education out until last year. Last year was the first time our state bar said, we need to have a CLE on the UPHPA. So that was like 9 years too late. But that was our state's fault for sure. And then this is just me like encouraging people to do this kind of work. But yeah, so that's kind of how it works in Alabama. And I'm happy to answer any questions that y'all have. I know there were some other questions that I didn't answer that I'm happy to answer.
Thank you so much. Oh, go ahead, Valerie.
No, I just wanted to thank you very much. I mean, that was a great overview of sort of where things are working and where things maybe weren't working. Other than having the bar and, educate and advising the judges, are there other recommendations that you would have, based on your experience as we move forward with this act? Either in, the sorts of partition actions that we're considering, or sort of post-enactment issues that you may see. Because one of the things, for example, that our title folks have recommended is that we look at expanding the protections of the UPHPA to all partition actions. And so if you have any other recommendations, I think we'd be very interested in them.
Yes. Yeah, I do. I can tell you my opinion on that. I think that would be amazing. And the reason I say that is there's this misconception just for a lack of understanding and like people who've never actually litigated these correctly.
Right.
There's this misunderstanding that like the UPHPA is making it more complex, and it's not. Like, I've done a ton of them. I can tell
Right.
you, in my opinion, because the rules are so like lined out, it reminds me of kind of like a probate case in a way, like the structure of like you know what the next steps are. Like you just have to follow them. And so I think it's fair to say, like, even if it's not heirs property, if you have a co-tenant that wants to keep the property, why should they not get the right of first refusal before it goes out on the open market? Like they're another co-owner who obviously wants to keep it. Why can't they get a right of first refusal built in through this UPHPA process before it goes out on the third market, on the third party sale? Because what's going to happen is you're going to disadvantage the other owners who may not be able to outbid some speculator in China or whatever, like whoever's showing up to go buy this property. I had one of those, so I brought up China. But you see stuff like that, and then you're like, your people in your county can't, they can't outbid the guy in Florida who can drop all this money that wants to move out to the Northeast. So I mean, I think it makes sense to expand it. I wish that Alabama would have done that, but I'll be honest, they made that heirs property definition so freaking broad that like I've only seen one other case where it didn't apply. But I do think that it's a good idea to go ahead and expand it to all partition actions.
Sure, that makes sense. And then I guess sort of a nitpicky point, do you know, so the description of what needs to be on the posted sign, that's in the statute? That's not okay.
That's in our statute.
Yeah.
So like, yeah, even like the dimensions. And then it's interesting because it says that you can ask the court to include the names of plaintiffs and defendants. So it's almost like defendant's attorney has to like say, judge, require them to put this on the sign too, but it just has like the minimum mandated things to put on the sign. And I hate the 11 by 17. I wish it had to be a bigger sign. Like I wish it, like that's like my husband had a city council campaign this year. I'm like, that's like a city council yard sign, but yeah, I wish it was a little bigger because I had one case. Well, I need to say this too from practice. I've never had a plaintiff's attorney that complied with that requirement. So you would see me filing like motions to dismiss for lack of proper service. And then the judge would just say, put the sign on the property. They would just tell them to put the sign on the property and fix it, or whatever. So that was fine. But if they were doing it, I had one where they did it. I had a pastor, I work in like rural Alabama, so really rural areas for the most part. A pastor drove by the property, saw the sign, but he was like, I had to get out of the car and go get my glasses. I'm like, if I had just been driving by, I would have just thought it was like a sign for the local farmer's market. So, I kind of wish that they had made it a bigger requirement because he said he had to stop his car, get out of his car, go find his glasses to read it. But he was like, if I had just driven by and seen, I would have just stopped, for a second and looked and made the call at that point.
That's really helpful. Thank you. Andrea.
Well, I just wanted to follow up on that. Thank you. Your presentation has been wonderful. It's been great to hear your perspective. On the signage, it sounds like, one, it should be bigger, and I don't know where we are with it in our draft, but also I'm wondering if it would be appropriately larger depending on the size of the property. So, that urban property has a smaller sign, but that larger rural property, those are much larger. So I don't know if that's feasible in statute or an approach, but I just wanted to throw that out when we come back to this and think in the future. And I'm curious your thoughts if
Yes.
that's a relevant consideration.
Yeah, so beyond that even, I'm like, why it should be required on every entrance to the property. So like every road that leads to that property that enters into that property should have that sign there. Like I almost wish it was like every corner, maybe not every corner, but on every side of the property it should be there. It's so that anybody could see it from every area. One thing that worries me is I can't remember if it says, I have my binder somewhere. I can't remember if it says it has to be on the facing the public road, but I think it can kind of just be anywhere, like at least in our state. So like imagine they put the sign like in the back where the hunting property is and like nobody sees it. Now that doesn't help landlocked I mean, if it's landlocked, there's nowhere to put it except for wherever the property is, anywhere on the property. But putting some kind of requirements for where it's supposed to go and how many signs are supposed to be posted and maybe a larger sign, I think is a good consideration for y'all to think through while you're working through this language.
Thank you so much. Jeff.
I just had a couple questions, and maybe they're irrelevant if we're talking about expanding it to all partition, but the timing of determination of heirs property is one I had. Like how does the timing and process work for the determination?
Yes. Yeah. So what I do I'm often on defense side, I'll be honest, but I do file partition actions occasionally. I will ask in my initial petition or in my initial answer, if defendant, that the court make a determination to declare the property heirs property. Like I want that done first, because how are we supposed to determine how this is litigated? It's because we have two statutes. The court's got to do that first. So it is very soon after, like I'm talking about at the first hearing, the court is making that determination if it doesn't make the determination before a hearing. Sometimes I did have a couple judges that said, well, you filed a petition, you served all parties. Parties had 30 days to file a response. They either filed them or they didn't. And no one objected to your claim, your allegation that it was heirs property. So I'm going to go ahead and declare it heirs property. And so, that's, and because I always put in my initial petition why I believe it meets the definition. And sometimes the judges will say, well, no one challenged it, so I'm going to go ahead and declare it heirs property. Most of the time, though, we have an initial hearing where I go ahead and put that evidence on. I have my client testify to what those requirements are, how it meets those definitions. And the judge I want it declared in the first order that we get, like the first order that's ever entered on this case, it needs to be declared heirs property.
I want to be respectful of Ms. Fisher's time, so we'll have the last question come from Justice Walters.
I'm not sure if the other question, Jeff, did you have another question too?
And I have time
because I really don't have a question. I just want to thank JC. So I don't want to interrupt where people have questions.
Mine can wait. It's all good.
Well, I just wanted to say that when we drafted this act so many years ago, we were hopeful that it would have these kind of results, but we didn't know. So hearing these stories is just so wonderful. Thank you.
That's great. You're welcome. I have lots more. So yeah, we should talk sometime. I got to talk to one of the Alabama drafters, and he said the same thing. He was like, we did not know it was going to have this effect. But I mean, it has had, I'll say this, I've never lost a partition case under the UPHPA. And by lost, I mean, I have never had a client that didn't walk away with a fair result, like where I was like, this was a grave injustice. The UPHPA makes it such that even if they lose the land, they at least walk away with the fair market value of their interest and not the pennies on the dollar. Whereas in the old partition cases where everything got sold at auction, I literally saw a client get an $8 check for their interest in the property because it was sold at auction. So
Yeah, and I think that's the sort of situations we've been talking about when we think about access to justice and how this is really an access to justice issue. So thank you for sharing that.
Absolutely.
We may have questions in the future. Is it okay if we reach out to you
Yeah.
and get your feel on things? I'd really appreciate that. Thank you.
Yeah, no, absolutely. And I think someone asked about, did Alabama look at the foreclosure notice provisions? Not to my knowledge. And I
Okay.
recently talked to one of the drafters in preparation for this meeting. Um, our notice frameworks are from the rules of civil procedure just for regular civil actions. Like that is just civil litigation. It runs under the circuit court. And so the only addition was that sign requirement, but it runs under the regular rules of civil procedure. And then again, I don't really see commissioners that much in these cases, but the court has discretion to appoint them. They don't have to, but if they do, they're supposed to be disinterested and impartial. I guess it could be because I've kind of known to do so many of these partition actions. The judges are kind of like, do we need a commission? I mean, JC's going to do the most. She's going to do the absolute most. And if, she can't prove her point, then I'll say no. But, and I'll be honest too. I work really hard to collaborate with opposing counsel. Like I work my butt off to get a result that works for everyone because I never want to leave it up to the judge, because I have literally had judges say, how am I supposed to decide who gets the piece by the gully or who gets the piece by the road? Y'all figure it out. Like, do you want me to figure it out or do you want to figure it out? Because I'm not going to figure it out. I'm just going to sell it.
Right.
So anyway, that's kind of my position on that. And then one question was, has the work in the court system in Alabama increased? I would say no. And the reason I say that, I tell people, when North Carolina, good Lord, God bless them, they are so worried that these clerks and their clerks are kind of like their probate judges, that it's going to put too much burden on them. Number one, I screwed up and said, well, how about you put it in a court where they actually have to be lawyers? That would be a good start. Number two, make the lawyers draft the proposed orders. Like y'all do everything else. I mean, judges generally will say, okay, get me a proposed order. That's what they should continue to do. Like they don't just do that in partition actions. They do that in family law actions, So put the requirement on the lawyers to draft those proposed orders, to draft those proposed notices. And then again, the workload should be the same because the lawyers should be doing so much work on the front end, like the title analysis, all that stuff. And if you follow the rules of the UPHPA, it lays out exactly what you need to do. There's not any question. And then there was a question about the budget crunch, and this is the last thing because I do want to answer your questions. Someone asked about do we have startup costs if we pass this thing? I don't think there were any startup costs in Alabama, and the only thing that they probably should have done was an educational startup cost, but they didn't. And there were no new offices, no new staff, nothing like that. It operated within the system that we already had, the existing judicial and probate systems. The additional costs that could be required would be appraisal costs. Guess what? Those either get paid by the plaintiff or whoever's asking, for the appraisal, or paid by the parties all together, or it gets deducted from the sale. So, I mean, the appraisal costs were paid within the cases, and they're typically case specific and they're born of the parties. So from the budgetary standpoint, there's not any extra startup costs. The only thing I would say is get people to roll out the education when you pass this thing.
Well, thank you so much, JC. Really appreciate it. And this has been a great presentation. So thank you for your time on it, which is 3 hours ahead of us. So
no problem. Oh gosh, no problem at all. And if y'all need anything, holler. I'm very transparent, as you can see, and I've turned into a Southerner now. So whatever. I'm from Illinois.
Where did you come from?
I'm from Illinois, but I've lived in Alabama for 8 years, and I'm married to a Louisiana guy. So I'm just gonna tell it like it is. Maybe that's not Southern, maybe that's the Illinois in me. But just if you need anything, holler, and I'm happy to help.
Thank
Great.
you very
Thank you
much.
so much.
Absolutely. Thank y'all. Bye.
Bye. All right. Yes, Amy.
I was just going to add that we don't have a meeting in February. I want to be, like Valerie said, respectful of everyone's time. We don't have a meeting in February. We will be getting back together in March. And we will send out materials mid-February, late February before that meeting. So you will get information just on a logistical side. That stuff will come out in about a month.
Yeah, and I wanted to say that one of the things that Gabe is putting together for us is a flow chart of how that next section works, because it's a pretty dense wall of text. So we want to make sure that we understand. I'm a visual person, so it's useful for me to see, how everything interrelates. So thank you, Gabe, for taking that on. Okay, anything else for the good of the order? We're a little bit over here, but I think that was absolutely worthwhile. And thank you so much, Jane, for arranging that for us. We really appreciate the chance to talk with JC. Amy and Gabe, can you stay on for a moment, please? But the rest of you have a great afternoon and enjoy the not raining that we've got at least for the next 10 minutes.
Thank you all.